Hi, this is Suzanne Bouchard, instructor for American Institute for Paralegal Studies. For obvious reasons, one of the most important topics that we learn about in estate and trust law class is the procedure for probating a will. In this lecture, I want to briefly outline the very basic steps that are typically followed in a formal probate proceeding. This information is covered in Chapter 12 of our text, Administration of Wills, Trusts, and Estates, the 4th edition, by Gordon Brown and Scott Myers. In Step 1, a petition is going to be filed with the court. Now, the petition will be either a petition for probate or a petition for administration, depending on whether or not the decedent had a will. The petition for probate is a formal written application asking the probate court to prove and allow the will, and to appoint the petitioner as the executor of the estate. Usually, the petitioner is someone who's been nominated in the will as the executor. If there is no will, probate proceedings commence when a petition for administration is filed with the probate court. This is a written application by heirs, next of kin, or maybe even creditors, asking the court to appoint somebody to administer the estate. In Step 2, notice is given to interested parties. After the probate court receives either the will and the petition for probate or the petition for administration, the court issues what's called a citation. This requires the petitioner to notify all interested parties that a petition has been filed with the probate court. In testate cases, Step 3 will involve proving the will. The procedure for proving the will varies by state, but many states have laws that allow a will containing a self-proof clause to be admitted to probate without testimony or affidavits of witnesses. In Step 4, unless it's waived, a bond is given by the personal representative or executor. Some states require personal representatives or executors to post a bond and also require a surety on the bond unless the will provides otherwise or unless all heirs agree to the appointment without sureties. In Step 5, letters are issued by the court. In this step, the probate court will issue either letters testamentary or letters of administration, again depending on whether or not the decedent died with a will. In testate cases, that is, cases in which the decedent did have a will, the court will issue letters testamentary. This is a formal instrument that gives the executor the authority to carry out the administration of the estate according to the terms of the will. In intestate cases, that is, cases in which the decedent left no will, the court will issue letters of administration. This is a formal instrument that gives the administrator the authority to carry out the administration of the estate according to the state's laws of intestate succession. In Step 6, an inventory is filed. The inventory is a detailed list of the assets of the estate, and it includes the value of these assets as of the date of the decedent's death. In Step 9, notice is given to creditors so that they can make claims against the estate. Creditors are allowed a specified period of time in which to file claims against the estate. Known creditors must receive a notice of the deadline. Unknown creditors are deemed notified by publication of a notice that specifies the period of time for filing a claim. Now, if a creditor does not respond within that period of time, their claim will be denied. In Step 8, debts, taxes, and expenses of the administration are paid. Once the deadline for filing claims against the estate has passed, the executor or administrator can begin paying the claims that were filed against the estate. The reasonable costs of administration will be paid. These include such things as attorney's fees, court costs, costs associated with publishing notice to creditors, that sort of thing. Also, taxes and creditors' claims against the estate are paid. If the estate is insolvent, that is, if there are insufficient assets to pay all the debts of the estate, claims are paid according to a priority list that is established by state statute. In Step 9, distribution is finally made to beneficiaries. After all the estate's debts and taxes have been made, the remaining assets, if any, of the estate will be distributed to the beneficiaries according to the terms of the will, or according to the laws of intestate succession if there is no will. In step 10, a final account is filed with the court. The final task of the executor or administrator is to prepare and file a final account with the court. The account is a listing of everything that the executor has received and dispersed during overseeing the estate. In some states, the filing of the final account formally closes the estate. In other states, the executor must also file a petition for discharge asking the court to formally close the estate. So those are all the very basic steps that are usually followed in a formal probate proceeding. Probate laws do vary from state to state, though, and a paralegal working in a probate law firm will need to be aware of not only the general procedures for probating an estate, but also the very specific procedures that are followed in his or her state. Now, if you're not currently a student at AIPS, and if you'd like more information about legal studies and careers leading to careers in the law, please visit our website at aips.com.